I will just touch some of the issues. We are living in magical times, and I remember magic used to mesmerize all of us because things used to happen suddenly, unexpectedly, and those things are happening these days. Uh, means for last maybe 5-10 years we are certainly magical times. Uh, Computer came, and then internet came, and then social media came, and then online teaching mode. So uh, fraction of days and years things are changing. That reminds me one of the Hindi line. Please excuse me my foreign friends, but the Hindi line is आदमी ठीक से देख पाता नहीं और पर्दे पे मंजर बदल जाता है. Means you are not able to see something, but things change immediately on a fraction of years, fraction of time, because of technology. What is the impact of technology? I will just give you a small illustration of my home. That my mother is 73 years, and she stays alone, and she is not good in English. She is not at all. She does not know computer. She deals with mobile. For 2 days back, she called me that she wants to buy a computer. I was very surprised. I said, what will you do with computer? You have a mobile phone. But no, I want to learn computer. And we all must have witnessed the fight for cell phone and which channel we have to watch among children. That is the impact of technology, and this is how deep it has gone inside our house. Now, these technological advancement and role of law, it is not something new. When I was doing some research work, I found an instance from 15th century. You will be surprised that how the law is connected to technology. In 15th century, there was a great technological advancement, and mechanized printing machines started getting their place. So when mechanized printing machines started getting their place, it became possible to publish something, and then you can spread the information comparatively in far more better manner. So after 100 years, it has further developed technologically, and information started spreading like anything, and the information of all types. So if you are not agree with the government, if the government is doing something, it is not that you can only gather, you can only protest, but you can pass the information from one side to other side through mechanical printing machines. So what happened in 1643, an ordinance was passed in UK, and the name of the ordinance was an ordinance for regulating of printing, and it required pre-approval of book publication, because book publication has become easier because of technological advancement of mechanized printing press. Otherwise, prior to that, it was manual printing press. So 1643, a law was passed to suppress the voice of publishers, suppress the voice of intellectuals, suppress the voice of democracy, which was indeed in its primary shape. 1644, 1 year later, John Milton has criticized this law, that no, this law is not required. Why should we get pre-approval for book publication? Due to technology and law, science, we have an opportunity to get the books published easily and to circulate it easily. What is the government required to do? Why should we get prior permission from the government? But you know, the governments generally, not only government, the powerful people, not just government, anyone who is in power, means they can be religious person, they can be political persons, they can be ideological persons, they can be in academia, they can be in media, they can be in government. They are worried that okay, something should not be published which criticizes me, which questions me. So therefore, John Milton in 1644 has criticized this law, and he said that truth should prevail and it will automatically be out of market. So if something is not correct, something is false, government need not to worry it, because it will go out of market, because people like truth. So 600 years back, technological advancement has made the information to move faster and faster, and now in 21st century we are finding we have internet, we have social media, that makes the information move from one side to other side on fraction of second. Just to further suggest that because there was great development, technological development in the area of printing, in 1733, because newspapers were publishing, and they are publishing very fast using scientific development, New York newspaper has published something in 1733 which the government did not like, and a sedition case was registered against them and seditious trial started. Fortunately, the editor was acquitted in 1733. This was another aspect of law, technology, and maybe judicial development. Now, with this brief background, I would say that, as everyone has rightly pointed out, that every development has positive and negative aspect, and so is social media, so is internet, so is cyber mode. So technology, I would say, is a new independent movement. How come it is a new independent movement? Because of non-availability of technology, we were very much dependent. Let me give you a small illustration. 20 years back, people used to come to Delhi in search of good library, in search of good research material, in search of good articles. But these days, we are not dependent on Delhi, we are not dependent on metro cities. Now, a Supreme Court judgment is here, and by evening, it is on our cell phone. I remember when I was studying in Banaras Hindu University in 90s, we had to wait for 1 month or 2 months for some Supreme Court judgment. So some judgment in South Africa, some judgment is maybe Nigeria, some judgment in any other place, some law is developed in some place. We required to wait for maybe 1 month or 2 months or 3 months. But today it is available on internet. So that has made us very much independent. We are no more dependent on big universities and elite universities and something like that. Second is, the monopoly of media houses has gone. Now, 10 years, 20 years back, the media houses had their own monopoly. Whatever they want to publish, they could publish. There was no independence. If I want to publish something, it was not possible. But now that is not so. If I want to publish something, I can publish on my blog. There are a number of online news media. So maybe I have no connections with Times of India. You may not have any connection with Washington Post, but you can write on your views on various online mode as well as on your blogs. Third is the issue of fairness. We are aware that media houses and sometimes the intellectuals and the governments and the parties, political parties, they sometimes give just one side of the story. They do not give whole side of the story. But these days it is not very difficult to find the both side of the story. So if you find a WhatsApp post, you find an information on internet, you can know what is the other side of the story, even if somebody tries to hide it. So it goes to fairness. So first is information, second is monopoly, destruction of monopoly, and third is fairness. That's why I say that it is a new independent movement. Now, to summarize this first part of discussion, I would say, for a law researcher like me and you, there was difficulty in accessibility of relevant research material, which has been certainly addressed to great extent. Now, Harvard Law Journal, you have to only subscribe, and that is available free of cost on your inbox. That comes every month. So is the Oxford Law Journal. Even journal of my institute, that is Indian Law Institute, which is the celebrated law journal of India, it is available free of cost. You need not to spend anything. You need not to wait for, you need not to come to Delhi. You need not to wait. You need not to be dependent on postal services. It is published, and that it is uploaded. Then it has become, of course, this technology has been being used by criminals, but at the same time technology is also being used to catch the criminals. Then coming while discussing this human rights aspect, we can find the subsidies and scholarships. These things have become easier, and the corruption money, the middleman, they have almost gone. I remember, let me give you a small illustration. Some of my students, they used to say that our scholarship is not coming because it will come through come through various means. Even if it comes in the university, what university, maybe clerical staff, sometime not all, but some of them, they used to do, they used to ask money, additional money, some money for distributing this scholarship. Now the scholarships, now the subsidies are going to their own bank account. So thanks to this Aadhaar, which was started by the previous Congress government, and thanks to this government, which has indeed applied these all facilities through Aadhaar, that the subsidies and the facilities are now available, and middleman and corrupt practices have to larger extent has been reduced. Now, two legal point I would like to just refer here is the registration of first information report. Now, in many cases, first information report, which is required to be registered in case of any cognizable offense, any crime, it is possible in many cases online. You need not to go to the police station. Similarly, virtual court. So, developing countries indeed, like India, I have heard about the online courts of USA and UK, but I've never heard about virtual court in India. But thanks to pandemic, that virtual courts have become a reality, and some of the hearings we have already enjoyed. So these are some of the illustrations, positive side illustrations of this technological development. Now, laws at international level, I think there is no convention which is required to be there, but there is a regional convention, that is Budapest Convention on Cyber Crimes 2001, and it talks about offences against confidentiality, integrity, ability to computer data systems, then computer related forgery and fraud under clause 7 and 8. Then article 9 talks about child pornography. Then article 11 talks about attempt at aiding and abetting, and in article 11 it has great significance these days, because social media has also become an instrument of abetting various type of hate speeches, hate against caste, hate against religion, even hate against state, hate against individual, hate against maybe one sex or other sex, hate against white or black. So this abatement has become maybe a distinct type of offense in the age of social media. Article 11 of the Budapest Convention addresses this. But at international level, I would say that it is high time an international convention is required. Of course, Budapest Convention is a convention which is open to anyone. And indeed, though it is a European convention, many countries like USA has signed it. India is also discussing that whether they should sign or not, and Article 32 is something that is stopping India not to sign this Budapest Convention. So my first suggestion would be that there at international level there had to be a convention to deal with cyber law, especially cyber crime, because they are borderless, and every country has a responsibility because every country is a victim. Coming to domestic law in India, I think my Indian counterparts know these all things. This would be just a refreshing memory. But maybe for my African friends, this would be new information. We have two types of laws. One is conventional law, which is here in our country for maybe last 19th century, last 18th century. So 1860 onward, we have Indian Penal Code, which is still existing. It has been amended many times. Indian Penal Code has been amended for the purpose of incorporating cyber law technology. For example, section 29A has been incorporated, electronic record has been recognized. Similarly, criminal law has been amended and 354C has been incorporated, 354D has been incorporated. I will try to deal with these offenses one by one. Now coming to the another convention law is CRPC. CRPC was first made in an organized form in 1898. It was present prior to that also, but in 1898 we had a CRPC and we modified this CRPC, and a fresh CRPC came in 1973. And then we amended it for the purpose of technology. For example, section 154 says that if a victim of rape approaches the police station, then there has to be a video recording. Her statement has to be immediately video recorded. So this is the recognition of technology in law in Indian jurisdiction. Now let me cite you one case from the Supreme Court, which is a type of revolutionary case, how judiciary has responded to technology and law. The name of the case is Youth Bar Association of India versus Union of India 2016. And in this case, the Supreme Court has ordered that all first information report means a report which is submitted to a police station regarding cognizable offense, means a type of serious offense. CRPC, we have our CRPC has Schedule 1. In Schedule 1 there are offenses categorized, so there you can find, one can find cognizable offenses. So all cognizable offenses has to be registered by the police. Youth Bar Association says that after registration of that FIR, within 24 hours they have to be uploaded. Indeed, a direction was given in 2010 by the Delhi High Court itself, but it was applicable only for maybe Delhi. So we already had a system of crime and criminal tracking network system known as CCTNS. So in investigation we are doing it. So this Youth Bar Association has ordered, and let me quote the order for you, is that the copies of FIR, unless the offense is sensitive in nature, has to be uploaded within 24 hours. So all FIR has to be registered, so one can see an FIR. You need to know the case name, you need to know the number, and FIR can be registered. First information report has to be registered. I am not aware whether it is happening in South Africa or whether it is happening in my friends from the foreign jurisdiction or not. If it is happening, please share the experience with us. If it is not happening, then please convey that India is an example where we are uploading all FIR. Only sensitive FIR is not being uploaded. For example, offenses which deal with sexual offenses, offenses which deal with insurgency, terrorism, sedition. So these type of offenses we are not uploading because there is a these offenses are very sensitive in nature. So this is my second suggestion to in this, that the South African counterpart can think of requesting their government taking clues from India, that the information to the police which are serious in nature should be registered, so that one can see what type of offences has been committed or has been registered. Third conventional law, I had dealt with two conventional law, IPC and CRPC. Third conventional law is law of evidence in India. Again, evidence law is not a new law. It was enacted during British days in 1872, and it was amended time, and then it was amended in the 21st century, and then digital evidence and many other evidences and many other provisions, some other provisions were incorporated to address the issue of law and technology under Indian Evidence Act. This is regarding conventional law. Now, do we have special laws? Like every country has special criminal laws or special penal laws. Similarly, we have special penal laws. So I would just quote three special laws for this purpose. Two laws can be called as IT Act. One is Indian Telegraphy Act of 1885. Though it is an act of 1885, it deals with technology. So we have addressed the issue of technology during British days, since British days in 1885. Then we have special laws on technology, and that is known as Information Technology Act 2000. This Information Technology Act 2000 is the basic law that deals with law and technology, and it addresses the issue of privacy also under enactment. Privacy has already been declared a fundamental right under Article 21 of the Constitution of India. But we have already addressed the privacy issue in Information Technology Act 2000. And violation of privacy has been declared an offence, a crime in India. The third special law is POCSO. POCSO also addresses, POCSO means the law that deals with crime against children, especially sexual offences against children. So this law especially addresses the use of technology for the purpose of committing crime. If time permits, I shall deal with that also. Now, coming to the point of social media, the social media does not need a recognition. Social media has become a part of everyday life, and I do not know many people who are not a part of social media directly or indirectly. So that is the penetration of social media in our life. I will just record one of the Supreme Court judgment. The name of the judgment is Amit Sahni versus State of Delhi. This is also known as Shaheen Bagh judgment. And I quote from the Supreme Court: we live in the age of technology and the internet, where social movements around the world have swiftly integrated digital connectivity into their toolkit, be it for organizing publicity or effective communication. Technology, however, is a near paradoxical manner, works to both empower digitally fueled movements and at the same time contributes to their apparent weaknesses. The ability to scale up quickly, for example using digital infrastructure, has empowered movement to embrace their often leaderless aspirations and evade usual restrictions of censorships. However, the flip side to this is that social media channels are often fraught with danger and can lead to the creation of highly polarized environments, which often see parallel conversations running into no constructive outcome and evident. So I think I have just 2 more minutes, so I will just conclude that social media is a double-edged weapon, and it has advantages and disadvantages. I had already dealt with some of the advantages of social media, and we all know the disadvantages, like social media has become a platform for forwarding false forward. Even the law students and law teachers are engaged in this. I am very surprised to know what stops them verifying the information. In the internet age, it is not very difficult to verify these all information. So I request all present here, I am very much sure that we all behave in a responsible fashion, but especially the students. Here I would request that when you forward a message, please verify, especially if the message deals with religion, deals with caste, deals with region, deals with any other sensitive issue. Please verify the information. I'd only say that in order to deal with the technological issues, there can be 3 or 4 suggestions which I am trying to forward to you all. And the suggestion is that if we want to make this world a far more safer and better world, which is free from these hate speeches, which is free from radicalization, where the media and the social media and YouTube is not used for terrorist activity, for radicalization purpose, we need to do 4 or 5 things. And those 4 or 5 things is, number 1, and that would be the concluding part. Number 1, educative means. So first is educative, second is persuasive, third is compulsive, fourth is coercive, and fifth is punitive measure. So I am trying to address that how to tackle the meanness of the negative side of social media or the online platform. First is educative means. What is this educative means? Educative means, or educative approach means, we have to educate each other. We have to start with our home, teach our children, our brothers and our sisters how to behave on social media, how to be responsible, how to be respectful, how to be respectful to the views of others. And then the schools and colleges should take note of this. This is educative means. Second is the persuasive means. What is this persuasive means? Persuasive means these type of seminar and conferences which should keep on arguing, which should keep on urging people to protect human rights, to be more responsible, and don't be carried away by various informations. Many of them are fake. Don't be carried away by false notions of rights and liberties. For example, right to self-determination. India is a victim of this right to self-determination, and in some of our states, people are being given wrong information about right to self-determination. We are a democratic country, and we have elections, and we have rights which are protected by the courts, and one can approach to the courts. So persuasive means are required not only to protect human rights, but to suggest people what actually mean human rights and how can be more responsible. Third mean is compulsive means. Sometimes the technology can be used to compel the enforcement of laws. For example, registration of FIR through technological mode. This is a compulsive mode. So this mode helps us keep something on record, and the police later on cannot manipulate. So this is the compulsive mode. Then fourth is the coercive mode. Coercive mode means departmental action if something goes wrong, administrative and civil action to errant police officers, to powerful people, to anyone who is committing some means intentional blunder on social media or maybe online media. Some departmental action has to be taken. So that is a coercive mode. And finally, punitive mode. Punitive mode is the last mode. If these all 4 modes does not work, then the criminal law should come in picture. And if somebody is using social media to radicalizing youth, to become them suicide bomber, to convey hate speeches against state, against religion, against caste, against black or white, against one country or other country, punitive measures should always come in picture. So I again thank the organizer. I again thank Bennett, especially Bennett University. I again thank Madam Dean, the foreign counterpart, and I especially thank Pawan ji for giving me this opportunity. Questions and comments are welcome. Thank you very much.